Columbia Sportswear sues Columbia University over trademark infringement. Imagine two giants clashing over a single word, Columbia. It's not just a name, it's a battle of brands, and it's heating up in the courts. Columbia Sportswear is suing Columbia University, claiming the Ivy League institution's merchandise is a little too cozy with its own iconic style. But here's where it gets controversial. Is this a legitimate case of trademark infringement or an overzealous attempt to monopolize a common name? Let's dive in. On July 25th, 2025, the Portland-based outdoor retailer filed a lawsuit against the East Coast University, alleging trademark infringement, breach of contract, and other violations. At the heart of the dispute, Columbia University's online store, where students, alumni, and fans can snag everything from shirts to sweaters emblazoned with the school's name. Columbia Sportswear argues that these items bear an uncanny resemblance to its own products, sold in over 800 retail stores nationwide. The company fears this could confuse consumers, and they're not holding back. Here's the twist. Columbia Sportswear has held a federally registered trademark for the word Columbia since 1996, specifically for its outdoor clothing line. In 2023, the two parties struck a deal. The university could use Columbia on its merchandise, but only if paired with the school insignia, the word university, an academic department name, or its founding year, 1754. In return, the retailer agreed not to sue. Sound fair, right? But here's where it gets messy. Columbia Sportswear claims the university broke the agreement just a year later. The lawsuit, filed in US District Court, highlights several examples of alleged violations. Think block font Columbia shirts without university logos, or sweaters in a shade of blue that the retailer claims is confusingly similar to its own signature color. And this is the part most people miss. The company tried to resolve the issue amicably last September, but the university allegedly didn't address the breach. Now they're demanding a jury trial, seeking to hold sales of the disputed merchandise, and even asking the university to recall sold items and donate remaining stock to charity. Oh, and they want treble damages, 3 times the actual damages determined by a jury. But let's step back for a moment. Columbia University has been in the spotlight for more than just its merchandise. For over a year, it's been locked in a high-stakes battle with the Trump administration and conservative lawmakers over its handling of student protests against the war in Gaza. The university recently agreed to a $200 million settlement to restore frozen federal funding, a move that sparked its own share of controversy. While the lawsuit doesn't mention these political troubles, it's hard to ignore the timing. Is Columbia Sportswear seizing an opportunity or simply protecting its brand? What do you think? This case raises bigger questions about branding, consumer confusion, and the limits of trademark law. Should a university be able to use its own name freely, even if it overlaps with a corporate brand? Or does Columbia Sportswear have a legitimate claim to exclusivity? One thing's for sure, this battle is far from over, and we'll be watching closely to see how it unfolds. What's your take? Let us know in the comments. Columbia Sportswear versus Columbia University. Trademark battle explained. Picture this, a massive legal showdown between an outdoor gear powerhouse and a prestigious Ivy League school, all over the simple word Columbia. It's a clash that's got everyone talking, and it's all about protecting a brand that's been built over the decades. If you're curious about how a name can spark such a fierce battle, stick around. We'll dive into the details that could change how you view trademarks forever. Based in Oregon, Columbia Sportswear has filed a lawsuit against Columbia University in New York, claiming that the university is stepping on their trademark toes by selling gear that's way too similar to what the apparel company offers. This isn't just a minor mix-up. It's a serious accusation that includes charges like trademark infringement, breaking a contract, unfair competition, false claims about where products come from, and not playing fair in business dealings. To break it down for anyone new to this stuff, trademark infringement basically means one company is using another company's name or logo in a way that confuses customers. Think of it like borrowing your neighbor's car without asking and then claiming it's yours. In this case, Columbia Sportswear argues that their brand is all about high-quality outdoor clothing, and they've been using just the word Columbia on stuff like shirts, hoodies, and caps for over 80 years, making it a household name without needing to add sportswear every time. But here's where it gets controversial. Back in June 2023, the two sides actually made a deal. Columbia University agreed that if they wanted to sell products with the name Columbia, they had to include clear markers that it's the university version. Things like their shield logo, a crown design, a specific C, or even their lion mascot. This was meant to avoid any mix-ups, kind of like how you might add your initials to a shared family recipe to make it uniquely yours. However, Columbia Sportswear says they discovered in September 2024 that the university was ignoring this agreement. They found items on a university's website sporting just the plain Columbia name, with no university-specific identifiers. And to make matters worse, some of these products even featured the Nike swoosh. That's a big deal, because Nike is one of Columbia Sportswear's toughest rivals, both based in Oregon, which could intentionally blur the lines and steal some thunder. Columbia Sportswear didn't just sit back. They reached out and demanded that the university stop selling these items and fix the issue. But according to the lawsuit, nothing changed. And the sales continued, causing what they call irreparable harm. This means the confusion is damaging their reputation and customer trust in ways that money might not fully fix. For example, someone might buy a university sweatshirt thinking it's from the sportswear brand and end up disappointed, hurting the company's image long term. Now the suit is asking a judge to step in and order a full recall of any products that use the Columbia mark without those required university symbols. That means pulling back items from everywhere, not just stores, but also from customers who already bought them, wholesalers, distributors, and even partners like retailers or marketers. On top of that, they're pushing for the university to get rid of or donate any infringing gear to avoid future problems. They also want to look at the university's financial records to see how much profit was made from these sales, and they're seeking punitive damages to punish what they see as willful misconduct. The case was brought forward by lawyers Jason P. Evans in Portland and Nika Aldrich in Seattle. And as of now, Columbia University hasn't responded publicly, though reporters are reaching out for their side of the story. And this is the part most people miss. While trademarks are crucial for protecting businesses, some might argue that universities have a right to use their own name freely, especially when it's tied to their identity. Do you think Columbia Sportswear is overreaching, or should the university have stuck to the agreement? We'd love to hear your take. Jump into the comments and let us know if you side with the brand or the school. Columbia Sportswear sues Columbia University out of a trademark infringement. Trademark clash, an unexpected battle over identity. In a surprising turn of events that might catch many off guard, Oregon's renowned Columbia Sportswear has initiated legal action against New York's Columbia University, accusing the institution of trademark infringement. The controversy centers around the university's sale of clothing items in its bookstore that prominently feature the word Columbia. Columbia Sportswear, with its legacy spanning over 80 years, claims that its trademark is synonymous with high-quality, active, outdoor, sporting and recreational gear, a reputation the company has carefully cultivated both domestically and internationally. But here's where it gets controversial. The company argues that the university's use of the name not only breaches agreed terms, but also amounts to unfair competition and violates contract stipulations. Digging deeper into the issue, the complaint outlines that in June 2023, Columbia University had consented to using the word Columbia on apparel, but only when paired with distinctive symbols representative of the school, such as the mascot or the term university. This agreement had enabled Columbia Sportswear to produce and sell apparel alongside other merchandise in the campus bookstore. However, the sportswear giant asserts that the university has repeatedly deviated from these guidelines, notably by distributing merchandise such as certain Nike-produced items that merely displayed the word Columbia without any additional identifying markers. By raising these concerns, Columbia Sportswear demands that the university immediately cease the sale of all apparel that they believe infringes on their trademark agreement. In addition, the company is seeking compensation for the economic damages they claim to have suffered because of these actions. The situation has ignited debates that many find both intriguing and controversial. Is the university overstepping its bounds, or is this merely a case of overzealous trademark protection? And this is the part most people miss: the balance between brand identity and academic legacy. What do you think? Should trademark rights trump historical and educational significance? Columbia University has opted not to comment on this pending litigation, leaving the dispute unresolved for now. As the case unfolds, it invites us all to consider where the line should be drawn between corporate protection and institutional expression.